Kena record ke, Mai?
Yeah, just for our record.
Okay, I know. Hi everyone. Hi everyone. I know this is a session we call it lunch and learn, but I don't intend to bore all of you lah.
No, this one is bubble tea session, oh.
Oh, this is bubble tea session. So it's supposed to be a discussion.
Macam wake up.
Stanley look very tired, I think late night yesterday, right?
I thought I always look so young and beautiful.
My young and beautiful partner. Okay, today I will start on our topic. We'll be pitching on corporate rescue. Okay, I am not sure on your understanding on corporate rescue. Like I mentioned earlier, I do not intend to share the details on corporate rescue because I think all of us here, we are either in DR or in CC team. I think we should be fairly familiar with our company's act. So yeah, today I'll be touching on how to pitch on corporate rescue. Okay, following us so far. Okay, so corporate rescue, your target audience. All right. Maybe I'll start with Xiangli, because Xiangli, you just asked me some question on corporate rescue. So maybe you can share with us. Why do you ask those questions to me the other day? What alarmed you to ask on that question?
Okay, I actually asked Manchan what is CVA. They call it corporate voluntary arrangement because I think one of our potential clients, they want to enter into a collaboration, or we call it, can be a JV, can be an acquisition of shares or assets, where this developer is now in the preparations for filing their court papers on this CVA. So roughly, I actually asking Manchan, how is this CVA works upon their filing? How many days of moratorium they can allow that they will be granted to the company to prevent them being sued by the creditors, and whether is there any extension, and whether our COVID-19 Act applicable. Yeah.
Okay, so I guess from what I gather, our potential client intends to JV with this developer who is planning to go on CVA, I guess.
Our potential client could be it's like a white knight to rescue the developer.
Okay, so Stanley use a very frequent word, white knight, because when you talk about corporate rescue, most often than not, it would involve a white knight, because the reason why people sought for corporate rescue is because they are facing financial difficulties. Okay, I mean, I always explain to people, money is like the water. Without the water, your boat cannot sail. Okay, be it a sampan or a kayak. So without water, your business cannot go far, especially in difficult time like this. Okay, I think although we are recovering, but yes, cash flow is very, very important. Most often than not, these companies here, they face difficulties in their cash flow. Okay, and there are signs. Okay, the number one sign is that the legal suit that they will be facing. This is number one sign. If some of your any of your clients say, hey, I received a writ today, a statement of claim today. Okay, I don't know what is this, but very simple. You ask for a copy of the pleadings. You take a look at the prayers. Okay, so long as it's touched on chasing back some money, okay, then you can proceed to ask them, is this the first one or is it the second one? According to my experience, most often than not, they say, yeah, I received some similar pleadings previously, but I didn't bother. So, so very likely they would probably have a judgment entered against them. Okay, and many more are coming towards them. So these are the signs that when someone told you that, yeah, they have received this writ, this is a sign that they may need this to go for corporate rescue mechanism. Okay, and yes, Xiangli has already touched on CVA, and there are two other methods that we can actually rely on. Maybe Kasun can help us on this. Do you know?
Hello. About CVA.
Stanley touched on CVA already lah. Any other method that you're aware of?
Actually, it's the matter. We are working on the same matter.
Sorry? Oh, you're working on
That's
the same
the
method.
only this method. Yeah.
Okay. Okay, so I'll give the answer lah. Technically speaking, when we talk about corporate rescue mechanism, we are only talking about CVA and judicial management. Of course, there's another method we call scheme of arrangement. Scheme of arrangement has been there since forever. Used to be known as 176 scheme. Okay, so technically speaking, this scheme of arrangement is not entirely meant for corporate rescue, but because back then, before the new Companies Act kicks in, so this scheme of arrangement is the only method available. So when people are facing problems, financial problems, they are facing legal suits, then they will sort for scheme of arrangement. Okay, so basically I start a bit with some background facts. This scheme of arrangement, any company can apply. Like I mentioned earlier, it's not limited to scenario where you are facing legal suits from your creditors. But when back then, I would say most of the cases when people file for scheme of arrangement, they are going for the restraining order. Like back then we used to call it, now they call it as restraining order also. So this restraining order can be understood as what we call moratorium nowadays under the two new corporate rescue mechanism introduced. Okay, so why people want to go for restraining order is to restrain other people from suing them. Okay, so most often than not, when they file for scheme of arrangement, at that point of time, they will apply for restraining order already. So it's basically the same. When you file for restraining order, if allowed, you will get a 3 months plus another 3 times extension. Okay, and this would effectively jam all the legal suits pending or to be filed against you. So you can get some breathing space, you can get your white knight and say, look, my business is a viable business, come inject some funds, help me to go through these difficult times. Then yeah, I'll share with you something. We'll come up with when some arrangement beneficial for both parties. Okay, so this is what happened back then. But of course, when we talk about moratorium, we just imagine this scenario lah. Okay, now you are acting for a company in difficulties, so you suggest to him scheme of arrangement. But what if you are acting for a creditor? What if your client comes to you and say, hey, this ABC company owes me money but doesn't want to pay? Then suddenly this ABC company, they have this restraining order with them. So effectively, you can't take any legal suits against them. So you see, you thought you have business to do already, can file it already. And suddenly you realize there's this restraining order, then you can't file any legal action against them. So effectively, it affects your rice bowl also, correct? So when you are in the other side, so you need to think of a way to set aside the restraining order, to look for circumstances, to set aside the restraining order moratorium, just depending on which side you are on. I think there are SOT and also the shield where you can both use. Okay, so we have these 3 methods here. Moratorium is what people are looking for. But let's say today someone in front of you asking you about this corporate rescue mechanism. Okay, according to my experience, I think there are five factors to be considered when you advise your client. So I think I will just quickly go through. Applicability, that's number 1. The complexity of the matter, that's number 2. Control of the company, 3. The moratorium. Okay, how easy you can get a moratorium or the period of moratorium, and last but not least, the cost of it. Okay, and I think about this, I mean, again, I will not go into how long. I will not tell you how long today, but I will just quickly go through. When someone come to you and ask you about this corporate rescue CRM, what are the pointers you should look for? A quick one. So first, applicability, because obviously all these three methods, right, they have different threshold. Okay, I think the number one most important point is the subject company, okay, who is considering this CRM. Is it listed? I think this is the first question to ask, because if it's listed, then CVA and JM is not applicable. You can only go for SOA. So it's the same like what we are seeing, AAX. I'm not sure if you are aware of. Okay, AAX, they have applied for scheme of arrangement for court convened meeting. Court has allowed it. So yeah, they came up with a scheme, okay, returning 0.5% to their creditors. So you can actually Google it. I mean, it's all over the news. Feel free to have a read. All right, second thing. Okay, normally I think we have the perception that if it's listed, it's a public company, correct or not? But what if the company is a public company but not listed? Okay, for a public company, right, but not listed, similarly, CVA is not applicable, but you can consider JM in that circumstances. Okay, so that's number one, whether if it's listed or whether it's a public company. Okay, second thing, who are you talking to? Okay, that's someone who came to you. Is he a director? Okay, there are a few categories here. Is he a director, a creditor, a JM, judicial manager, liquidator, or shareholder of the subject company? So as a director, of course, he is steering the subject company, isn't it? So he can actually consider all three methods, okay, depending on the factors that will be dealt with later. Okay, if he's a creditor, what can he do? Okay, generally as a creditor, I mean, of course, CVA, we call it corporate voluntary arrangement. So that, right, is to be used by the company itself, not by the creditor. Creditor is someone outside, isn't it? Okay, but the creditor actually have two ways. They can try to apply for JM, or they can try to apply for scheme of arrangement. But normally, it's not usual for creditors to apply for JM or scheme of arrangement. I mean, you try to imagine this. You are a creditor, you apply to rescue the money who are owing you money. So it actually doesn't make sense. So here I will touch a bit about some circumstances of misuse where I am aware of. Okay, first, JM. There's actually a case known as Spacious Glory. Not sure if you all heard of that. Okay, this creditor actually applied to put that subject company into judicial management. Okay, but throughout the proceeding, they actually revealed their intention to get the control of the company, because they know that the subject company is receiving some money, but the company is not paying that money to them. So they want control of the company so that the money will be paid to them. So this is the intention. But like what we mentioned just now, judicial management being one of the corporate rescue mechanism is not to wrestle control of company, but rather is to save a company. But of course, in this Spacious Glory case, the JM application has been shut down. So this is what happened. Okay, as for SOA, for what I know of, when, I mean, again, it's very weird. When you are a creditor, you are applying to put the subject company under scheme of arrangement. If they want to be helped, right, definitely the company itself would be the first to know. Of course, as a creditor, you wouldn't know what is in the company. I mean, logically speaking, you wouldn't know what is in the company. You wouldn't know what are the assets owned by the company, and definitely you would not know the cash flow situation. So it's a bit weird, right? As a creditor, you are applying for scheme of arrangement. But what I know did happen was that creditors, okay, subject company, right, they use creditors to file scheme of arrangement and also to file restraining order. Okay, this used to happen where they will file this application, 176 application, at different courts throughout Malaysia. Okay, so because for an example, today the company is based in KL or Klang Valley or whatsoever, then they may go to like what, some smaller courts, maybe Alostar, Sungai Petani, Muar, then they'll file in their 176, file in an application for restraining order with certificate of urgency, then quickly after they get the order, right, so immediately they get a 3 months breathing space ready. Then they actually repeat throughout Malaysia at different courts. So this is to frustrate the creditors from taking action against the company. So don't be surprised, back then, when it's carefully planned, they can get restraining order like multiple times. The maximum I've seen, they got 4 times throughout Malaysia. Then of course they will try to extend the restraining order. Okay, if they can't get, then immediately file a different court already. So this was what happened. Okay, again, you may so moving forward, you may meet some judicial manager or liquidator. Okay, so if you are speaking to a judicial manager or liquidator, it's pretty simple. Okay, so you see, a company may already be put into judicial management. After the judicial manager take over the company, right, they can still consider to put in a CVA or SOA application to actually revive the company. Now, this is similarly applicable to the liquidator. They can use this as well. Okay, last but not least, if you are speaking to a shareholder, okay, if you are speaking to a shareholder, the only option available to you is to go for scheme of arrangement, because this scheme of arrangement, like I previously mentioned, is not restricted to only restructuring the debt, but also to restructure the company also. So one of the example they can actually apply to do a reduction in share capital, or maybe take over other related or subsidiary company. So this all depending to their plans in their mind. Okay, so this basically deals with applicability. Okay, after going through everything, let's say after going through this first factor, right, applicability, you would roughly know in these 3 options which are the better options already. You know, I mean, not to say better option, you know what you can do or what you cannot do. So this is the first step. Okay, second step, you look at the complexity. All right, complexity, I think there's only one, I mean, of course, the number of creditors, but I think the main point to look at is actually the secured creditors, whether there's any secured creditors. Okay, for an example, if there's a secured creditors, then you cannot go for CVA. That's a no already. You can actually ask, do you owe any money to bank? If his answer is yes, then you say no CVA, then immediately the answer becomes quite apparent, like it's either JM or SOA. Then next, maybe you consider JM. Okay, but I can tell you this, if there's secured creditors, although yes, you can apply, but secured creditors can have the veto power to object to the JM application. But of course, there's a exception. The exception is that if the JM, the judicial management, involve public interest, okay, then the secured creditors would not have the veto power. But of course, this is to be argued in court. I'm just bringing this up to you so you will know. Okay. Secured. Okay, for SOA, of course, SOA being the most lenient way to restructure a company, actually they don't actually matter whether you have secured creditors or unsecured creditors. If they're secured creditors, most likely they'll be placed in another class of creditors where in most scenario, they would have a separate arrangement for these secured creditors. After all, their debts secured, isn't it? So they ought to have better offer. Okay. Okay, next point to consider is on the control of the company. All right, to put it simply, under CVA and SOA, right, let's say you apply and it's approved by the court. Okay, the control of the company remains in the director. So because some people might say, I want to I want to dictate how my corporate rescue can run. So if that's the answer, then yes, I go for CVA and SOA. But in contrast, this judicial management, right? If it's approved by court, a judicial manager will be appointed by court. So again, for this judicial manager, is quite similar with liquidator, where it's court appointed officer of court. So ultimately, they owe larger duty to the court and also to the creditors. So basically, if you apply for JM, okay, they basically give off the control of the company already. The JM will get to conduct how the company is run and also what are the plans to be carried out. So yes, this is very important. Okay, the fourth point, the length of moratorium. Okay, this is related. I mean, I can first share something. This is quite different than what the usual moratorium we know. Not a bank moratorium where you doesn't need to you don't need to pay your loan. Okay, but this is to restrain legal action against the company. All right. I'll give an example for JM. Once you file the JM application, immediately you will get automatic moratorium already. But of course, this is quite a limited moratorium, but enough to stay most of the pending legal action or filing of legal action already. So if the JM application is allowed, right, then of course you will get a power kind of moratorium for 6 months, and before the expiry of the 6 months judicial management, and the judicial manager, if he thinks that it's necessary, he can apply for another 6 months. So there's a 12 months total of moratorium here. Okay, and next, CVA. Okay, similar with judicial management, CVA also have an automatic moratorium, but CVA only has an automatic moratorium of 28 days. So the difference is quite apparent, right? 6 months versus 28 days. So logically, you would go for JM, isn't it? Okay, but this CVA, the 28 days of automatic moratorium, it actually can be extended, provided it gets support from the creditors in creditors meeting. So the timeline in CVA is actually quite short, where you have to move really fast. So looking at the timeline, you would know that CVA is applicable to debts of less complex. Okay, next I will go to scheme of arrangement, where I already mentioned just now. I mean, it's not automatic. You have to apply. You have to file a separate application for the restraining order. Okay, once allowed, it's actually 3 months. Then you can, but upon further application, you can actually go up to another 9 months. Okay, so SOA is not automatic. You have to apply. Okay, if you can't get, then your creditors may proceed with the legal action and proceed to get a judgment against you. Then it would further cripple your plan to restructure the company. So this is the main point for moratorium, which is to stay all the legal action, so the company have some breathing space to restructure the company. All right, last but not least, the cost of CVA, SOA, and also JM. All right, for CVA, of course, like I mentioned just now, is the simplest one. Of course, they need to appoint a nominee, but nominee's job is to monitor the process of the arrangement. Okay, but the involvement is not as much as judicial manager, where judicial manager, like I mentioned, would be taking over the company, running the company, and of course that would involve costs. Okay, so CVA is the cheapest because you don't need to appoint anyone, but a nominee who is not that into your daily activities, is just overlooking the process of the restructuring. Okay, going into SOA and JM, okay, it's quite similar if you ask me. JM, for one example, they would come before you file a judicial management application. you would have to speak to a qualified insolvency practitioner already. Okay, that would be the liquidator. So in usual case, the liquidator would ask for a mobilization fee, depending on which liquidator. Okay, in our case, I'm actually handling a judicial management case right now. In our case, it's around 100,000. That's for mobilization fee lah. So it's for that piece of paper, that consent to act. I mean, the client pays 100,000 is for that consent to act by the judicial manager. But of course, if it's not allowed, usually the judicial manager, the nominated judicial manager will refund the money. They'll retain some money, but they'll refund most of it. But this mobilization fee is what needed if your client would want to go to JM. So in our case, our JM application was allowed. So the fee for the judicial manager actually kicks in. So in our case, I got him a pretty good deal. Monthly, I would say it's around 20,000 per month. So there you, let's say 20,000, you times 6 is 120,000 already. Okay, that's the fee that you have to look at. And there's actually another success fee. If the judicial manager successfully restructure your company, settle all your creditor, get your creditor to vote yes to whatever statement proposal that is tabling, then there's another success fee. Okay, so depending on which liquidator you go for, so it can vary depending also on how you negotiate the deal. Okay, so you look at our JM here, we are looking at like what, 200,000 already for the first 6 months. If it's get extended, of course, the monthly fee will get running also. And actually that doesn't include our solicitor's fee. Okay, applying for applying for this JM, it would incur some cost. In our case, we are only charging, if I'm not mistaken, per application, it's around 50,000+. Okay, this is our fee for that. But of course, if the judicial management is allowed, of course, the judicial manager needs representation in court also. Need to file, maybe in our case, updates to court. Then in that case, there will be further cost to that. All right. Okay, it's actually very similar to, I'll move on to scheme of arrangement. Okay, it's quite similar to judicial management, except the fact that there's no one appointed to go into the company, but they would have to appoint a corporate advisory firm to draft the scheme for them. Okay, again, depending on which firm you go to, I mean, the charges can actually vary. All right. So these are basically the things to consider if you are talking to someone who asks you about this CRM. So any question so far?
Hi Manchan, Chinu here. I have a question. I'm not sure if I heard it correctly from you just now, but you mentioned much earlier that there was this case that I'm not sure, was it you who did it or you are familiar with it, and that company filed 4 cases to buy time?
Oh yeah. I mean, I witnessed. I did not file it. You were back in the days where.
Okay, so basically it is the company which is in trouble is the plaintiff or the applicant, is it?
Yeah.
And then who is it, like an ex parte thing, or who
Yes,
is on the other side?
It's an ex parte thing, so there's no one at the other side. One case that I have witnessed, a creditor filed for the 176 scheme and also put in an application for restraining order. So I mean, being ex parte in nature, the judge will only ask, hey, can I grant this? Then you open your company and show him like, yes, Yarif, you can. So most often than not, the judge will say, okay, all right, order in terms. So that is how they get the restraining order.
I see. And it's, I mean, because ex parte is only going to last for a very short time, right? After a while, it's going to be inter partes, right?
No, it's not that ex parte that we know. But of course, for it to be inter parte, you see, creditors filed, but the creditor is actually arranged by the subject company. So the only one who will come to object are the other creditors.
Other creditors, correct.
Who don't know anything about this application, and suddenly they'll go to case management, then suddenly there's a court order here, then they'll be shocked. They will look for lawyers. Then by the time they look for lawyers, and then when they decide to maybe to set aside this ex parte order, so time has passed already. And if I can describe, it's like a guerrilla war. They run around,
Okay.
yeah, getting orders after orders. Then ultimately, as a creditor, you suing the subject company is to get money, right? Then
Yeah.
ultimately, you are spending more money playing guerrilla war with these kind of people.
It's throwing good money for bad money.
Yes.
Short,
correct.
I see.
So people will
And
get
then
something very
another thing that I couldn't really understand about this, right, is because I had a previous client that was doing a scheme of arrangement. But they are in a financially very healthy position. And they have bank creditors as well. So I suppose that's why scheme of arrangement was probably the only method. But they are financially very healthy, and they basically did that to restructure the company. Would you know why that was actually chosen?
That honestly, I'm not aware of lah. I only know of some scenario where they use this SOA to restructure the company. That I don't have any personal experience. Yeah.
Okay, sure. Thanks. All right, I don't have further questions. Thank you.
All right. Thanks, Chinru. Anyone?
Salam, I have a question.
Hey, Xiang Li, I expected that.
Salam, can I ask about the CVA? You talk about the proposal. Who is actually supposed to draft the proposal? You said the company will engage a consultant.
Nominee.
Nominee. Who is that nominee? The
nominee is actually, again, is an insolvency practitioner. I mean, that would be, that would be a liquidator lah. But their job is just to supervise. But of course, being a supervisor, they will be the one drafting the proposal required.
So those meaning those proposals usually are not done by the lawyer. They will be like insolvency practitioners. They have that experience to assist them in restructuring their debts, and then come up with the proposal.
I mean, if you ask me, we draft the statement of proposal, but of course, the usual case is that the liquidator will tell us their plan, and of course, we will need to do the drafting. Maybe I'll share with you one example. I have seen a very badly drafted. Okay, the scenario is like that. It's abandoned project. Okay, it's some shop lots, 3-story shop lots. So it's half built, if I'm not mistaken, until 70 or 80% completed. But this shop lot, right, they are construction on a already subdivided title. Okay, so the company was wound up. They were put under this scheme of arrangement. So there is actually a scheme lah. Okay, but the scheme was so badly drafted in the sense where it didn't consider the scenario where all these shop lots they already have their individual title already. So in short, nothing stopping any of the buyer purchaser to do a transfer, isn't it? Okay, so this is a scenario where we are acting for the white knight who has put in money and successfully built, continue the construction until they got the CCC. Then that's all the problem will come out lah. Because according to the scheme, right, this purchaser, owner purchaser, they have to pay a certain amount of construction cost. For an example, if your shop lot is like 3,000 square feet, then you have to pay me X amount of money times 3,000 square feet in order for me to continue the construction. Okay, and I, as the white knight, I have to continue to construct no matter you pay me or not. But if you don't pay me, I can take the shop lot. So what is in for the white knight is that if this purchaser or owner, they pay, then my earnings lah. I mean, at the first place, the white knight actually came in not to be a nobleman, not to get any profit, right? They are coming in to get profit, correct? Okay, if you cannot pay me, I take the shop lot, which is also a fair deal lah, because I mean that location is actually quite prime. Okay, but why I say the scheme was badly drafted is because they use wordings like purchasers, purchaser of the shop lot. But throughout the years, right, maybe some people use the title to borrow along already, then already transfer 2 times, 3 times. Okay, some of the cases it went to auction. Then suddenly the winner, the purchaser in the auction, he was like, hey, I didn't buy this property through auction, knowing that I need to fork up so-called construction costs. So there are disputes there lah. And because of this dispute, I mean, it actually dragged for a few years, you see. So that's why I think drafting of the scheme ought to be done by a lawyer who has relevant knowledge, okay, on maybe NLC or other areas.
Manchan, if I may, I just want to follow up on what you have just explained, right? So it's interesting that you mentioned that why a white knight want to do this to start with. He wants to make money, right?
Yeah.
So maybe can you share with us why, to start with, any party will want to be a white knight, or should I say investor, in this sort of circumstance? Like, what is the benefit? What's in there for them?
Of course, that's a business decision, but ultimately it's driven by the profit. Okay, and this, if you ask me, is quite a risky business.
Exactly.
Okay, but if everything goes smoothly, then that's quite a good money, because you don't need to worry already, right? You just go in, take over the possession of the site, continue whatever construction that is uncompleted. Yeah.
So I suppose when you say like that, it seems to suggest that the white knight is typically a competitor of the existing company, or someone who has like in a similar business.
Not to say so lah. Not to say similar. Okay. If you ask me, this kind of white knight, right, normal, usually they have this very fetish appetite towards this project gantung one, usually. Usually.
I think, yeah, I will also add on, I think white knight usually they have money lah. So they have money, then they will pick all these abandoned projects that have the capability to revive the projects. So of course, like Manchan said, you look at the location and whether the projects are worth for them to just go in, because they just want to revive the projects. And those white knights are usually, they have the cash flow, strong cash flow.
Correct, but if you have so much cash flow, right, I'm sure you want to put your money where it's
Why
not
not
so
do other things?
yeah, exactly. My point being is that why pick this sort of, unless you have maybe a specific I don't know, soft spot.
But to my hometown, Johor Bahru, also we actually have a few abandoned projects, which was also rescued by all those white knights. It's really abandoned for like since I was born until when I was graduated. Then it was rescued, it was revived, became a hotel. The Double Tree Hotel also done by the white knight, I think, in Johor Bahru. They are like developer. They are really like keen to look for the abandoned projects, so to speak.
Yeah, cases like that. I mean, in the example that I just mentioned, if I remember correctly, right, when it was abandoned, the shop lot, the purchase price of the shop lot is not more than 400,000. So after it is completed, right, so basically the white knight say, you didn't pay me construction costs, okay, in the stipulated time frame. So now I pay you back the 400,000. This belongs to me, So I mean, it's quite funny, right? You constructed the unit, somehow you pay back the fella of the purchase price, and you want the unit. I mean, that's because of a very simple and obvious reason. I mean, because the shop lot worth 3 million, so worth paying 400,000 for 3 million, isn't it? So like what Xiang Li mentioned, the white knight has a strong cash flow. Don't mind, I pay you cash, I want the property. Yeah.
Yeah, just Mr. Lam, one more question, sir, about the court order for the scheme of arrangement and judicial management. At the end of the day, we will get the court order, right? But for the CVA, do we have a court order, or
no,
it's just a proposal?
CVA is just for filing only. You don't need a court order to pass it, but you have to file it. You have to file it in court, so you will get the automatic moratorium and everything. The procedure will go according to the Companies Act.
So if let's say that ended out their arrangement are okay, done by the nominee, it's a successful arrangement, then they can move on. If not, then it's considered like drop off already.
Yes, correct. But in any event, the moratorium for CVA also not very long. So you see, 28 days plus like what, 60 days, if I'm not mistaken, subject to verification. So it's like 3 months only. So can or cannot, by the end of 3 months, you know already.
So by the end of 3 months, if let's say cannot, then the creditors are start to sue the developer. Lah. If can, then they will settle by themselves. Lah. So those settlement agreement will be drafted by lawyers. Oh?
True.
I see. Okay. Thank you.
Okay, any other question? No more question, then I ask question. I simply pick. No, just kidding. Don't so stress. Okay, so yeah, if no more question, then we end the session. Usually everyone nodding very happily. No, seriously, I won't ask question. Okay, all right. Thanks everyone. Enjoy your weekend.
Thank you. Thank you,
Okay,
Machan.
Machan. Bye-bye.
Thank you. Bye.
Thank you, Machan. Thank you all. So our next session will be on 19 November by Siang Lee.
Thanks for your reminder, Mike. Siang Lee, okay, next
Siang
one.
Lee, yeah, Siang Lee.
Okay, bye.
Finally,
Okay,
bye-bye.
Thank you, bye. Thank you.